a number of these reverse acquihires are a pretty big departure from that idea, where instead of everyone participating in this great event, a select group of folks are getting a windfall, are getting a dream job in a top AI lab, but then a large number of folks are getting left behind.
We're doing these things that are sort of awfully like acquisitions, but on paper they look like something else. I will say too, I love this kind of stuff because this is what lawyers have been doing ever since there's been lawyers. Like we try to have a policy on stuff and then lawyers come along and figure out ways to get out of it. I don't know how scared they are of substantive liability, but they certainly could face it eventually. Big acquisitions have to be reported to the federal government before they're executed. So short version of the story is most deals above $125 million in value of acquired assets have to be reported.
And for many of these AI deals, these are multi-billion-dollar deals.
Yeah.
So all of them, if they had gone through a traditional acquisition, would be reportable.
Oh, for sure. The filing obligation under HSR is totally distinct from whether the transaction is illegal or not.
In the AI space, it can be difficult to get intellectual property protection that could otherwise protect you from competition while you're waiting out these time periods. When you have technologies that lack intellectual property protection, companies rely on speed to market that can be the driver of that need for really fast approval timelines.
I agree with both of you, I think, in what you've said, which is this mainly seems to be a timing issue. It will be inevitable that the antitrust intervention will happen. And when it does, the question will be not whether there was some competition, but the question will be, was it so little, though, that this was nevertheless a monopoly? And more importantly, did the winner who got that dominant position do it by means other than just creating a better product than everybody else?
So welcome. We're going to have a really interesting discussion today. Recent headlines have been dominated by tech giants like Google, NVIDIA, and Microsoft, effectively absorbing startups like Windsurf, Character AI, Grok with a Q, and Inflection AI, not through traditional acquisitions, but instead by hiring their leadership and senior engineering teams and getting non-exclusive licenses to their technology. So to discuss whether this is a legal loophole that might become a new norm in the AI industry or might get dashed by antitrust regulators, we're joined here today by my CSU law colleague, Professor Chris Sagers. He's an antitrust expert and author of United States versus Apple, Competition in America. And we're also joined by my husband, Chris Toswell, a software engineer, former product manager at Facebook, and employee number 20 at an Andreessen-backed startup. So before we discuss some of the legal issues, Chris T., can you tell us a little bit about some of these Acquihire deals and what they look like with a few examples?
Sure. I think framing it as taking a slight step back and talking about the contract of what it is to be at an early stage startup and why people join is important to think about this whole thing. Because in general, the idea of joining an early stage startup is you're agreeing that you're going to work late nights and long hours and really, really hard to build something new and great, and potentially for lower pay than you might be able to get at a larger company. But in exchange for taking that risk, you get upside when the company has some event, like it gets acquired or goes public. And that's sort of this ethos that Silicon Valley is built around. And there have been a number of these acquihires or reverse acquihires in the last 2 years that are a pretty big departure from that idea, where instead of everyone participating in this great event of being acquired or going public, a select group of folks are getting a windfall, are getting a dream job in a top AI lab, but then a large number of folks are getting left behind, sometimes in a company that's has no resources and no IP, and sometimes it's spun down immediately. And so the one that sort of hit the news the strongest was probably the Windsurf acquisition, but there were a number of these in the last, I said since 2024 was when it really ramped up. Just to name a few, there's the Microsoft acquisition of Inflection AI, where the co-founders were hired and the model was licensed, and then the core business sort of continued, pivoted, but again, when you're dealing with this sort of cutting edge tech and you lose your bright people, it's really hard to continue. Similarly, with Amazon acquiring Adept AI, Google's acquisition of Character AI, Meta's acquisition of Scale AI,
You said these
and
are
then
acquisitions, but can you
sorry,
explain a little bit?
Acquihires, yeah.
Yeah, can you explain a bit more, just an example of what that looks like? What is an acquihire and what's one example of that? Take the Google Windsurf case, for
Yep.
example.
Yep. So the basic the Windsurf example is that initially Windsurf, it was announced slash rumored that OpenAI was going to acquire Windsurf, and that was going to be a classic sort of acquisition for $3 billion, which was going to be a pretty great event for the company. They were sort of positioned as company number two behind Cursor as a code generation tool, but one that was well loved by many folks. And unfortunately, the Microsoft OpenAI acquisition of Windsurf fell through in part because of terms that Microsoft had access to anybody who any IP that OpenAI acquired, and because Windsurf's core offering directly competes with Copilot, there was sort of a problematic thing. And so it was then announced that that deal fell through. Anthropic cut access for Windsurf to their sort of early models. So Windsurf actually had sort of premier access to the latest and greatest from Anthropic, which few, if not, I'm not exactly sure about the terms, but very few people had access like Windsurf did. But after that deal fell through, Anthropic cut that access. And then rather quickly, Google stepped in and said, okay, we're going to acquire the key folks in the organization and license the technology. And so they paid out essentially to the investors in the company about $1.2 billion. And then 40 employees joined Google's DeepMind, including the founders, but about 200 folks were left in the company, and the CFO was promoted to being, I believe it was the CFO, another C-level person was promoted to be the CEO. And they initially said that they were going to continue to develop the company and continue to sort of press on. However, having lost their key staff, having lost their access to Anthropic's best models, that really put them in a tough spot. And then shortly after, Cognition announced that they're going to acquire the remainder of the Windsurf IP and team. However, the terms from that were not a sort of upside. There was not a lot of upside for the rank and file employees.
You were saying, I think when we were talking about this the other day, that that deal would have required extremely long hours for those employees at relatively low rates with a little equity. Is that right?
Yeah, so there's very little officially released about this because the company, that acquisition doesn't have the sort of public scrutiny on it. But what has been reported is that the remaining Windsurf folks were offered either incredible hours or to take 9 months of pay. And so essentially, many voiced that they felt that they were being pushed out of the company.
Mm. This sort of inverse of quiet quitting, right?
Yes,
All
exactly.
right. So let's bring in Professor Sagers on this. Can you explain a little bit about why this might be happening? What are these companies trying to avoid from antitrust regulators when they do an acquihire instead, or this
Mhm.
licensing arrangement instead?
Yeah, yeah, yeah. Yeah, no, thanks for having me, first of all. This is a totally fun topic, and I hope we get into this. A lot of what we have to talk about may be really going to stuff that's kind of in the weeds, like regulatory
Yeah, please.
details. But the big picture here is really very fascinating, and we're talking about these specific kind of deals as quite recent. This reverse acquihire thing is a recent innovation, but in some sense, the bigger whatever social problem is a really old one. It's like how do we fund innovation basically? And acquiring startups for 30 years or more has been a major off ramp for founders. It's like how do we fund innovation? Well, we give a big boon to those startup founders who figure out something good and make it big. And there was a time when they would make it big by doing their IPO. In the 60s or 70s, you might have just you invent your great product, you make money, then you go public and you get rich. But that's evolved over time. And for a while, the norm had been that startups wouldn't do IPOs. They wouldn't go public at all. They'd be acquired by incumbent firms. I have a feeling there are 500 podcast episodes already examining why we went to the acquisition model instead of IPO, and that's interesting in its own way. But now we're not doing acquisitions anymore. We're doing these things that are sort of awfully like acquisitions, but they on paper they look like something else. I will say too, I love this kind of stuff because this is what lawyers have been doing ever since there's been lawyers. Like we try to have a policy on stuff and then lawyers come along and figure out ways to get through it, get out of it. So that's what's going on. So that's the 40,000-foot view. I hope it's okay if I try very briefly to say what I think are some of the regulatory details that are probably at play here.
Yeah, that'd be great.
So this has been mostly told in the press so far as an antitrust story, I think. And antitrust is what I do. So I'm going to talk a little bit about the antitrust that could be applicable. So, okay, let me say first one thing, and it won't be immediately apparent why I'm saying this, but it's going to be valuable later on. Antitrust is, it's big and it's complex and stuff, but it basically boils down to 3 rules. First, you can't have conspiracies with people that you compete with. So like Google can't say to Bing, hey, let's not compete with each other anymore for search, or let's fix our prices for search. So you can't have those kind of contracts or agreements. Another thing you can't do is you can't be a monopolist. So even if you're not agreeing with somebody else, if you do stuff to make sure that you become the one guy in the field and nobody else can really compete with you, that may be illegal. The third thing that antitrust says is, likewise, you cannot acquire your competitors in a way that kills off competition. So Acquihires has been told mostly as a story about that third rule, the acquisition rule. So antitrust regulates acquisitions basically through 2 different rules, both of which matter here. The first one is the basic rule that says some acquisitions are illegal. They're illegal when they hurt competition too much. So that basic rule, for people keeping notes, is Clayton Act Section 7. And we're probably going to be walking a line here about how far in the weeds is too far. And you can ring that alarm bell at any point you want. But there's a little bit of weeds here that I at least find interesting. So I think Clayton Act Section 7 has a bunch of words. It's a long, complex statute. Here are some words in it that I think are quite significant to this acquihire business. Clayton Act Section 7 basically says the following. Any person, that is, it may be illegal if any quote unquote person, and person is defined as lawyers usually define it to mean not just human individuals, but companies. So deal can be illegal if any person acquires either the whole or any part of the stock of another person or the assets of another person, if the effect of the acquisition may be to substantially lessen competition or tend to create a monopoly. So that's a huge mouthful to basically say if you acquire another firm in a way that will reduce the amount of competition that benefits consumers in your market, that can be illegal. Okay, but Congress said it in that handful, and therefore we have to know what those words mean. And it sure looks on the surface like the reason that people are designing these acquisitions in this way as acquihires or reverse acquihires is to avoid the applicability of this law. We're not acquiring stock. We're not acquiring assets. Leave us alone. All right. Second rule that matters here. So we got a first rule, Clayton Act Section 7, that makes some deals illegal. There's a second rule that everybody knows about in principle because we hear about it in the papers all the time. And that is the rule that says big acquisitions have to be reported to the federal government before they're executed. So this takes place under a statute called the Hart-Scott-Rodino Act, or HSR, as we say. HSR says, again, it's a complicated statute, but in the simple version, it says all those deals that I just talked about that could be subject to Clayton Act Section 7. One person acquires the stock or assets of another person. A deal like that has to be reported to the feds before you execute it if the deal is big enough. And there's a nitpicky little rule about when deals are big enough, but basically it's like this. If the value of the stuff that you buy is 125 million bucks or more, and the parties to the deal are big, so basically one party I think the rule is one party has to be at least $25 million in value, the other has to be $250 million in value. Then your deal is reportable. And when they get to a certain size, it doesn't matter how big you are. If it's more than $500 million, you have to report it. Okay, so short version of the story is most deals above $125 million in value of acquired assets have to be reportable. All right. So the thing that happens with this statute is not that it makes anything illegal. HSR itself doesn't make anything illegal. The business end of it is to say, if your deal is reportable, you have to report it. And if you don't, by the way, there are nasty little penalties. Like, I think the penalty right now, the statutory penalty is $50,000 per day of continuing violation. So if you do a deal without reporting it and they catch you a year later, that's $50,000 a day for a year. And the courts are not sympathetic to defendants who try to say, "Oh, it's our honest mistake, Your Honor. They sucks to be you."
And for many of these deals, when we're looking at a lot of these AI deals, these are multi-billion-dollar deals.
Yeah.
So all of them, if they had gone through a traditional acquisition, would be reportable.
Oh, for sure. Yeah. The reverse acquihire deals that we're talking about, I mean, I took a look today. Most of them are like in the $500 million range or bigger. So yeah, if they were truly subject to the Clayton Act, then yeah, they'd be reportable. Not a lot of question. All right. Well, as I say, the business end is you got to report it. If you don't, you get a big penalty. And then what happens is there is the quote unquote waiting period. So basically, the parties to the merger have to wait until one or the other of our two federal antitrust agencies says we're not going to sue. And you can't consummate during that time. There are also relatively strict rules governing like pre-consummation coordination. So you can't like report your deal, run your two companies independently, but then coordinate their opportunities as if their activities. That's very seriously prohibited, et cetera. So it's a big pain for those companies that get stuck with the waiting period. One other consequence of this thing, which I think probably is not very important in understanding why we're going through these hoops to find loopholes, is that there is a filing fee. And to we mere mortals, it sounds like a lot of money, but it's a drop in the bucket compared to the size of most of these deals. I think the typical $500 million deal, the fee is $265,000. Okay, so that's money, but it's like that's what you'd pay your law firm on this deal for I don't know, a month of work or something. Okay.
And so how long are those waiting periods? What
Good
does that typically
question.
look like?
Yeah, next step. So waiting periods. First of all, okay, so everything about this is complex. The simple version of it, though, is for most deals, the waiting period is not long because virtually every deal reported under HSR gets approved very quickly. They're not subject to challenge. The agencies can look at it very quickly and say, yeah, we wouldn't sue to challenge this. For those deals that are more serious or of more serious concern to the government, which, again, let me stress, is a tiny fraction. And I'm going to say a little bit more precisely how small a fraction it is. The waiting period can be very long. For the tiny handful every year that the government considers very serious, the waiting period can be like year and a half, 2 years. All right. For even those deals that get more serious consideration, though, which there's some that, they're just not that likely to generate a lawsuit from the government, but it takes them a little longer to look at it. That will take like a couple months, typically. Okay. All right. Final thing I want to say about these regulatory background details is, like I said, it's a tiny fraction. So over the last many years, the average per year of reportable deals has been like 5,000 to 6,000. In the US economy, there are 5,000 or 6,000 mergers big enough that they have to be reported under HSR. Even in really busy years, like the Biden administration happened to file in absolute numbers a large number of merger challenges. But the biggest year ever was like 50. All right. So like 50 deals out of 5,000 generate really serious government challenge. So, I mean, this is a little bit of the sort of head scratcher problem of the reverse acquihire, which is that it seems to be a lot of effort to go into avoiding regulatory burdens that aren't really that bad. I mean, a tiny fraction of deals will generate a lawsuit. And obviously that's usually a deal killer. Like if the government threatens to sue, more often than not, the parties just abandon the deal. And it is true that, again, for some very small number of deals, the government can hold up the deal for months. And in this, in all corporate sectors, that's bad, particularly if one of the companies is publicly traded. Like that, that bad news hurts the stock price. It sucks. In very cutting edge technology, obviously it's crucial. I mean, 18 months it's a whole new generation of technology by the time we get to merge. So there's that. But again, it's like most of these deals would fly. They'd get approved in a month or so.
Mhm.
And you pay your $200,000 fee and we're done. So minor question why they're doing it. Hey, last thing. I said that was the last thing I was going to say, but this really is the last thing. There's a reason that so few deals get challenged. And that goes to the state of the substantive law of mergers and acquisitions. What I mean is, under our current law, under that first rule, Clayton Act Section 7, that says some deals can be illegal, it's actually really hard to prove that a merger is illegal. It's extremely difficult. Um, Only a certain small category of deals are ever challenged, and they are these deals that are horizontal, as we say, meaning that one company is acquiring another company and they produce some product that is in head-to-head competition. All right, so Google and Bing. That's a horizontal deal. And if it's a horizontal deal that also happens to be a hugely concentrating deal, meaning that it will leave the market with only a few players left, those are the only deals that are ever challenged by anybody. And that's why we can get 5,000 reported deals and 50 challenges, even in a heavy year. So, okay, so all of that said, some of these deals probably would be taken quite seriously as a legal matter. A $500 million deal involving head-to-head products, government's probably going to take a close look at that. Yeah.
And when you look at, for example, the Google and Windsurf deal, you're looking at a market where, as Chris T mentioned, that there's only a few folks that are making AI coding tools and that have the capacity to do that, and only a few major companies that have all of the huge basic models,
Totally.
Google, Anthropic, Microsoft, OpenAI. And so if you're taking one of only two major competitors in the coding area and
Yeah,
absorbing that into one of the companies that is one of the leading,
for sure.
I
I
don't know the
mean,
best model for it, yeah.
if it's two companies down to one, it's virtually per se illegal. That merger is almost automatically illegal. If it is four companies down to three, in other words, if a merger will leave a market with only three major competitors, that's likely to be challenged by the government. If it is five companies down to four, it's likely not to be challenged by the government. We always say in antitrust, a rule of thumb that, this isn't written down anywhere, but a 4-3 is the line in the sand.
Now, does it count as a horizontal transaction if you've got this situation where there's maybe two major competitors in the coding space, and then they get acquired by a company that could start
Yeah.
developing something in the coding space? Does
Yeah,
that count
yeah.
as horizontal?
Excellent question. And it's a gray area in the law. The question is typically that particular question is answered in the following way. If there's another emergent technology or a new, a potential competitor in the market, how soon are they likely to get to market? And generally speaking, the courts say, unless they are very likely very soon to enter the market, they're not part of the present market.
Mm. And now maybe Chris T, can you give us a little more insight into what the market looks like for some of these AI models? How are they structured and how many competitors are there?
Sure. And so I think, that from my rough understanding of antitrust and competition, the general tactic that is used by the large companies is you just sort of try and increase the aperture of where my competition is. We're not competing in this market. We're actually competing in a much
Absolutely.
larger market.
So in other words, once we get into litigation, the parties fight over who's really in the market and who's not.
Right. And so that's how they try and argue that, we're not
For sure.
making it we're not removing competition because we're competing against all these other folks,
Right.
right?
There are 500 people in my
Right.
space. Guys, this is crazy. Right.
And for AI coding, there's, there's a handful of tools which are sort of these AI powered IDE, and an IDE is an integrated development environment. Basically, if you think about like what Microsoft Word is for writing an essay, an IDE is a tool for writing software. It has a bunch of interfaces and niceties to make it easy to view your project, write a bunch of different files, link them together. And these tools have existed for 30 years in various forms. And so in in terms of the ones that are AI native or created from day one around AI, Cursor and Windsurf are the premier ones. I think there may be a few smaller ones, but not particularly notable. And then there's a whole class of these tools that I've said have been around for decades. Microsoft has VS Code, and those tools, there's one called IntelliJ, and there's many of these tools. Those tools are now sort of having plugins or add-ons into their system so that you can still use that original tool, but it can then connect with an AI system. And so you have a similar sort of workflow or similar access to AI tooling, but a product that's been around for many tens of years. And so I would say if you're worried about hollowing out competition of pure AI coding tools, then yes, the removal of Windsurf from Windsurf versus Cursor is pretty meaningful. But if you look at the overall landscape of ways in which you can write software that may or may not be AI enabled, there's a lot of different options out there. And there's sort of low code tools and things like that for folks who aren't actually writing software, but are just building things out of effectively code-based Lego bricks. So code development as a space is pretty diverse. And so I'd be curious about where they would draw the line about what competition is being removed.
I wonder, I wonder about how much competition you could actually have for that non-AI native company in the AI space. Is anybody ever actually going to use that if their goal is to do fully AI enabled coding?
There are reasons. So these tools are being rapidly built into the existing ones. And for example, VS Code, which is Microsoft's de facto solution for writing software, has a huge install base across the enterprise internationally. And if you can get the upside of using AI tooling to make your VS Code work close to how a Cursor or a Windsurf would work, it seems like that's a good decision for a lot of folks because now you don't need to go through an enterprise procurement process. All of your staff already knows how to use one of these existing tools. And depending on how good that integration is, it might be the same or even better. The in the same sort of way as Chris was talking about going into the weeds on the legal side, we could go into the legal the sort of the nuance of AI code generation, but essentially AI code tools come in a bunch of different flavors, and they're getting significantly better very fast. If you look at what Claude Code can do, and you can read articles talking about this right now, but and I have personal experience of this, like using Claude Code to generate code today is night and day from what it was even 3 months ago, and an entirely different universe from where it was not a year ago. It's just not like, and
So that,
so in
that tells us
general,
a little bit. That tells us a little bit about how critical that several month window of regulatory approval might be in this space.
absolutely. In my mind, and I'm not a lawyer, and I'm not a fly on the wall on where these deals are being made, but I generally think that the driving forces are the timing that all of these companies are in direct competition for talent, for gaining market share as fast as humanly possible. OpenAI and Google have both declared code reds for competition so that they can win AI. And so I don't think that they're being driven by a concern of paying some fees or reporting some things. It's the year timeline where they can't integrate these tools into their own stack, where they can't bring the talent into their own efforts, is probably the primary driver of this.
That makes sense. And so you have both the speed of technology development that can be the driver of that need for really fast approval timelines or really fast ability to get these deals done. But then you also have, I mentioned from an intellectual property perspective, that when you have technologies that lack a lot of intellectual property protection. Companies rely on speed to market. And in the AI space, it can be difficult to get intellectual property protection that could otherwise protect you from competition while you're waiting out these time periods. So, for example, if you have a patent, then you might be fine waiting a few years for regulatory approval because you're still going to be the only one on the market able to sell that product. But with AI tools, they're generally viewed as algorithms, not patentable. If you're merely applying existing AI technology to new spaces, that's likely not going to be patentable. And companies generally rely instead on trade secrets, which are generally held by these senior engineers and the
Mhm.
CEOs that are being transferred over. So I think that could be part of the driver here. So coming back to Professor Sager's, now that we kind of have some insight into why companies might not want to go through that regulatory approval process, do these acquihire deals potentially get around those rules for needing to file for approval? And what are the pros and cons of that approach from an antitrust perspective?
Yeah. Good question. And I don't think we know the answer yet. As you know, the feds did a big investigation on one of these, and I think they would like to find this a violation of the reporting regs. So the Federal Trade Commission administers a set of regulations under the HSR Act that says what's reportable and what's not. And the government is going to have a little bit of trouble saying that a mere acquisition of labor is subject to the statute, right? For one thing, this is a little weird, probably won't be that significant. It's almost quaint, I think, from an antitrust lawyer's perspective. In 1914, Congress passed a statute, Clayton Act Section 6, that says labor is not an article of commerce. So Congress seems sort of like it was exempting labor from antitrust. They did that because if they didn't, the fear was that labor union organizing was going to be considered an antitrust violation. But nobody really knows what it means. Nobody really thinks that labor isn't a market protected by the antitrust laws, or that conduct involving employment can't be relevant to antitrust. But here we are. We have a statute saying labor is different. A bigger problem, probably for immediate purposes, is that the Clayton Act and HSR both only apply to stock and assets.
So the question
And
is that an asset
yeah,
then?
exactly. So, and nobody knows. It hasn't really come up. On the one hand, it's not like a person's employment relationship is not an asset for antitrust purposes. I'm almost certain of it. And hiring somebody away from a competitor is not subject to Clayton Act Section 7 in and of itself. I'm fairly sure. Although, again, we just don't have a lot of guidance. What I think is likely to, a contrary point, which I find interesting, is that when the government applies both of these laws, Clayton Act Section 7 and HSR, applies them to particular deals, they have to value the assets being acquired, the companies being acquired, and they absolutely assign a component of value to the value of the workforce. So, what are you going to do? I don't know. A hard question is going to be whether merely hiring somebody away could ever be an acquisition subject to one of these laws. And I don't think we'll know until we have litigation on it. I think the government is going to put on their big boy pants at a certain point and sue one of these companies and say the violation in question is that you didn't report under HSR and this was a reportable acquisition. And we will have to wait for a court to tell us whether that's true or not. The easier question, it seems to me, is licensing IP. Like, most of these deals don't involve outright acquisitions of IP, which plainly are asset acquisitions. But I think, the law is fairly clear that even non-exclusive licensing is in principle an acquisition of something that could be subject to HSR. So my guess, if the government wants to litigate, my guess is the government's probably going to win. Like, these are actually reportable. A whole different question is that a good policy? Is this the right way to go? Should we be stopping acquisitions in a market where technology is developing this fast and holding them up for 2 years or whatever? I don't know.
I
I will
wonder.
say I
Go
will
ahead.
say I did a little math on my phone. Even if, like, you take that $50,000 penalty for the entire year of your
Failure to report.
consummated acquisition that was worth $500 million or whatever, that's still only 20 million bucks. I think
Right.
they might just be willing to say, fine, screw you
They
guys. We're
probably
gonna,
bake that into the cost of the acquisition.
right?
Right.
Like, oh, fine, whatever.
Yeah.
I love it, by the way, that one of the most brazen of these deals was a Google deal, which Google did while it was being sued by the same federal government that it's supposed to
Yeah.
report to in two separate antitrust cases, both of which it lost.
Yeah.
I don't think they're scared.
Yeah.
Or they're operating from a place where they believe that winning the AI game is winning the
You're
farm. And
right. It's surely worth it.
if they lose it,
It's
they've
a
lost anyway.
multi-trillion dollar space that they're going to win and own. Like, sue me for $20 million. Fine.
Right.
Right.
Yeah.
Are there any other, besides that 50K penalty, are there any other sort of recourse that happens from that, like a divestiture or other changes that the government can then force to have
Well, if the
happen?
government, yeah, okay, so that is relatively significant. If the government, the $20 million penalty is one thing. If one of these deals is challenged as a Clayton Act Section 7 violation, the government absolutely can get divestitures. That almost never happens. And the lawsuits themselves, lawsuits for violation of Clayton Act Section 7, they're very rare and they mostly don't win. So again, I don't know how scared they are of substantive liability, but they certainly could face it eventually. One thing about that, by the way, is the filing obligation under HSR is totally distinct from whether the transaction is illegal or not. Like, I agree with both of you, I think, in what you've said, which is this mainly seems to be like a timing issue. They're just avoiding regulatory holdups. And I don't think they particularly care about whether whether there are penalties or anything like that. That's wholly distinct, though, from whether these deals are legal or not. And whether they're reportable or not does not make them legal. And by the way, even if, let's say, one of these deals is primarily an acquisition of employee talent, and even if a court says, you know what, that's not an acquisition of assets subject to Clayton Act Section 7. Remember something I said at the very beginning of this, which is that I would eventually explain why it matters that there are three rules in antitrust. Even if one of these things is truly exempt from Clayton Act Section 7, it's also subject to it's going to be subject to Sherman Act Sections 1 and 2, which say you can't conspire with your competitors to limit competition and you can't be a monopolist. And I think there's not a huge amount of mystery that a lot of these deals are the so-called killer acquisitions. Like, you're acquiring not so much because your target has great IP that you just couldn't develop on your own. You're acquiring a competitor and making it, neutralizing it. So, if the government does sue to challenge one of these, which who knows, they might, the government will assert two different causes of action. One is that it was an illegal acquisition. The other one was that it was monopolization. And the monopolization part will not depend at all on what's an asset or what's a stock or what's an acquisition.
Oh, interesting. So theoretically, taking in a bunch of key employees in a way that, and potentially also these investor arrangements where the investors in the original startup are getting paid out and the employees are being left behind with a shell of nothing,
For sure.
that could theoretically contribute to monopoly.
Absolutely. Because yeah. I mean, whether it's an acquisition or not, you're taking a competitor and making it no longer a competitor.
Although in this AI space, I wonder, can we really have a monopoly when we do have these major players? We have a few major players, at least,
Sure.
Google, Anthropic, OpenAI.
No one believes that Google doesn't face some competition in search. It's just that it's not enough to stop it from being a monopolist. And that's a federal court held last year that it was a monopolist.
Yeah. So do you think it's possible that could happen in the AI space too? Let's say, a lot of people are now saying that Gemini is cutting way ahead of some of these other competitors. So could that change?
Yeah, I mean, I think it's inevitable that the antitrust authorities will have something to say about this eventually. It will, I sort of believe in the antitrust mission. I want antitrust to matter. It will be inevitable that the antitrust intervention will be too little and too late, and it won't have much impact. But it'll happen. And when it does, the question will be not whether there was some competition, but whether the fringe of competition that may have existed for Gemini or whatever other product happens to claim the field. The question will be, assuming that there's some competition, was it so little though that this was nevertheless a monopoly? And more importantly, did the winner who got that dominant position do it by means other than just creating a better product than everybody else? You can have a monopoly if you do it through, as we say, competition on the merits, but you can't do it through things like what Google was alleged to have done in the search case, right? And you can believe in that case or not. Reasonable minds differ very much about whether that was the right outcome in that case, but the court believed that Google did things other than just make a better product. And under our law, you're not supposed to do that.
And I wonder, this ties into another concern that I had with the intellectual property side, which is, can it contribute to the unlawfulness of the behavior from an antitrust perspective if a company is, for example, overvaluing the intellectual property when they're making these deals? So I'll give an example of Character AI.
Mm.
Google's 10K reported that it received $2.7 billion of goodwill and $413 million of other intangible assets, getting a non-exclusive license. And yet, after the deal, Character AI continued to make chatbots, which I would think would be the consumer goodwill, and stopped with the LLM development or the large language
Mm.
model development, which is what Google is focused on.
Right.
And so I wonder, and especially with many of these things not being, there's no patent around it. This is all potentially trade secret information, where they're trying to get the black box behind some of these technologies
Yeah.
as what they're acquiring. So, you know, are they overvaluing the intellectual property in that situation? What goodwill could possibly be worth
Yeah.
$2.7 billion dollars for a
Listen,
chatbot that they don't use?
I'm a fundamentally misanthropic skeptic of human character, and this just contributes to everything I believe. Because again, Google did that even as they were getting sued
Yeah.
by the federal government for very similar stuff. Like the okay, so in the search case, a thing that struck everybody as soon as that case came to light, the fact that wasn't really publicly known in that case was Google started paying Apple like 20 years ago, big paychecks every year, not to install anybody else's search capability on iOS devices. And in the early years, the amount of value, it seems like might have been perfectly reasonable. Maybe it was perfectly reasonable even by the end. But even Google itself says, look, default placement on the iPhone doesn't give us any competitive advantage. It's not worth it. But they were paying Apple $20 billion a year for it. Okay. I think they were paying Apple $20 billion a year not to invent its own search engine,
Yeah.
right? And a lot of people do. And a federal court also agrees with me. So yeah, I mean, it was legally relevant in that case that overpaying for something that didn't seem like it was worth it was circumstantial proof that the real purpose was anti-competitive. So
Interesting.
yeah, that it seems to me straight up they're paying that company not to make their own LLM anymore.
Interesting.
Yeah.
Chris T, do you have any thoughts as to with some of these deals, could Google or Nvidia or these other companies be essentially trying to stop the startup from competing effectively in the large language model development space?
I have complex thoughts there because one of the one of the challenges now is if you're trying to build a frontier model, you need an incredible amount of compute resources that is just out of grasp of most startups. Now there's cases of, especially in China, these sort of low cost models that are being developed, which is really interesting. And it'll be interesting to see how that continues to develop. But the vast majority is the sort of very expensive, high compute development. And most of the startups you see, and it's been true since 2022 or so, are generally wrappers around, or harnesses is the new more popular term, where someone is building a layer or orchestration on top of one or more of these models to use them to go do a thing. And like in the case of Windsurf didn't build their own model. They're a wrapper primarily around Anthropic, but they just created a tool chain that made it very effective for reviewing and writing and structuring code, which is a great business. And so,
For sure. I
yeah,
I hate to interrupt, but I just like to
please.
say this has also been a key little theory in a number of antitrust cases in the last several years, and a key issue in the most important antitrust case of the last 40 or 50 years, which was United States versus Microsoft. Those technologies, I don't know, they potentially undermine the privileged status of a dominant firm. Like, compute, the expense of the compute is a great bulwark against competition, right? Like if nobody else is going to, like that's, it's kind of like natural monopoly theory. Like if nobody else can afford to build this necessary resource, I don't really have any competitors.
Right.
But somebody might build a tool that allows other people to compete without having to build that thing.
Right.
right? Which is a devastating blow to the monopolist who spent a whole lot of money building their monopoly. And the antitrust lawyers, enforcers all get that.
Yeah, I mean, I think the sort of without going too far afield, I think one of the sort of key open questions on the AI space in general is the commoditization of tokens and the
Mhm.
generation of content,
Mhm.
where recent metrics have shown that all of the top models, frontier models, are sort of converging on performance. Some of them are slightly better in one way or another, but it's not how it was 2 years ago or even a year ago, where there was a very big gulf between the first model and the next model. And so, if these platforms become commoditized, then it becomes the platforms on the tool chain on top of them that becomes more interesting as a business, because if you can easily swap out one model for another, you don't have as much of a moat, and that
Right.
incredibly expensive compute machine you've made
Yeah.
is
Yeah.
harder
I'll,
to
I'll tell
do.
you that the feds, not that many of them are technology experts and they don't get computers, but they get that.
Yeah.
Right.
That's good. That's encouraging. There's not a lot of
Oh, yeah.
places where you think the government regulators truly understand the
Uh,
technology enough to apply their relevant
you
standards.
know, the lawyers themselves mostly don't, and I don't, but we had to learn these aspects of competition in this space during Microsoft 25 years ago, and everybody gets that now.
Wow. So I want to talk a little bit more about, all right, so now we know that there might still be a potential antitrust risk for these, but maybe the companies just don't care
Mhm.
because they're able to proceed with the deal. These are not the kind of deals that can easily be unwound
Mhm.
through any kind of government order, like an acquisition might be able to be unwound.
Yep.
And so now the question is there actually a problem in the marketplace for doing this? And where
Mhm.
does that problem arise? Maybe that problem might not be just with competition between the entities, but also in how it affects employees.
Mhm.
So, Chris Toswell, maybe you can tell us a little bit more about how these acquihire models, where the CEO or leadership and the intellectual property are being transferred, and sometimes the investors are getting paid out, but the employees aren't. How does that impact the marketplace for startup employment?
Yeah, no, I think that the the impact on the startup ecosystem is probably the thing that I feel most concerned about, because I think I'm one of those hopeless romantic types about this sort of idea of the few people in the garage building something great and working long hours and then having this great success of either the IPO or the acquisition. And it very much undermines that, because in all of these cases, some folks were left behind. Only a core group of folks, the founders, key engineers, really participated in the windfall of the acquisition. And generally speaking, the investors received some amount of payout. Usually, it's been said it's about 2x, 3x their investment. So not a home run, but also not a bad day for them. It's not going to zero. And in a world, if you sort of zoom in on the Windsurf outcome, in a world where the acquisition of by OpenAI had failed, sorry, the acquisition by OpenAI had failed, and then the access to models was being cut because of it, then if you're an investor, you're probably pretty concerned, because you've put a bunch of money into this business, and the best acquisition opportunity has just evaporated poorly, and you're the number two player in a space that it's probably going to be even more competitive, as Google was then moving in with their anti-gravity platform. So there's other big code first or AI first coding platforms that have come out in recent days. So, you know, if you're an investor, you could see your money potentially going to zero. So taking a deal where you're getting 2x or 3x your money back sounds like a great gift. And so that, yeah, I think for the investors it seems like a decent deal. For the founders, it's potentially life-changing amounts of money. And but for the rank and file folks, especially the ones who are non-technical, it's generally the salespeople, the marketing people, the ops people, who are not the ones participating in this outcome. And it's, I can't imagine that it's not going to change the shape of startup hiring. I've was looking for different conversations about it, and so far it doesn't seem that any hiring practices have changed significantly. However, several headhunters and human resources folks are now talking about that you really want to have that sort of conversation when you're joining a startup, saying like, especially if you're coming on as an executive of an early stage startup as a non-technical executive, so like chief marketing officer or something like that. Classically, as a C-level person, you will have various acceleration triggers on your deal so that you might be given some amount of equity in the company. But if you had joined and then your equity typically has a 1-year cliff, meaning that you don't get any of the equity until 1 year in, and then you have some amount of it vesting every month from there going forward, usually over a 4-year period is pretty much the standard. But if you're an executive and you join the company and then 18 months in, there's an acquisition, generally speaking, the terms of your employment say, okay, you've only been here for 18 months, so very little of your stock is vested. But because this acquisition occurred and there's been a meaningful change in the structure of the business, you're going to get all or some of the equity as sort of will immediately vest. And that's to ensure that you get to participate in that acquisition and that windfall, even if at that moment all of your equity would not have been vested. So typically, senior folks have deals like that set up, but those deals, as of today, generally don't include terms like these Acquihire terms. And so if you're a C-level person and you're not the person who gets to go over to the new Acquihire company, you might not have anything to speak of from that. And so, I've heard rumblings that is going to be changing, but even in that case, those are only the executives who can sort of make that, who would get sort of double trigger or different sort of terms to their hiring contract. Where again, if you're a director or manager or IC, it would be very uncommon for you to have any sort of special deals in your hiring agreement. And so
And
I
those
don't know.
folks don't have access to the lawyers that have knowledge about this issue to know that they need to have that added into their employment contract. Typically, they're just accepting the employment contract however it's written, or maybe they have someone reviewing it for an hour and then signing that agreement. So they might not know going into this that they are potentially getting screwed going down the line. They might be working there for a few years and never realize that this is a potential risk.
Absolutely. I think, especially in the tech world, because Windsurf was sort of a high visibility company, because so many coders were using it, that people became more aware of this issue than if it was a company that wasn't so in the middle of sort of the engineering tech space. And so I think it gained more visibility than another acquisition might have. But on the other side, if you look at sort of from a labor perspective, it's probably, one of the worst times to be in sort of startups in tech in software engineering. When I got my software engineering degree, it was generally considered the gold standard that you'll always have a job, you'll always have a very above market pay because people need folks who can understand software and write it. And very rapidly, AI is clearly closing the gap on generating this software. And so companies are not going to need as many employees for those applications. Now, they'll still need folks for other roles for sure. And I think that the people who continue to skill up and focus on the latest tools, there'll always be a market for people who really apply themselves and stay abreast of the technology. But for many folks, I think the hiring prospects are grim. There's, general hiring in tech is I think at the lowest level since the pandemic, but it's a pretty challenging market to get hired in, and then that's compounded with even if we join the thing and we succeed with an asterisk, you may not see a windfall from it, which I think is sort of fundamentally a
I
breakdown
mean,
of this idea.
there's a couple of super interesting questions, I think. Like, I wonder how much the risk has increased as a result of this. Like, I mean, there was always risk. Joining a startup or funding a startup is always risky. It may have been a pretty safe bet, at least some of the time, but it was always risky. And how has it changed? I'm interested too. Like, I mean, this specific problem with the employees who thought they were protected by particular language in their employment arrangements, and they're now getting the shaft. I mean, that's a compelling story. I wonder how this affects the VCs though, the people who put their money in it.
So
I'm
in a lot of
guessing.
these deals, they tend to have an arrangement to get their money back immediately at the
Yeah.
time of the acquihire, which
Mhm.
I was very shocked by. I don't know how they arranged for that kind of structure where
Mhm.
the investors managed to get, more than what they put in back at the time of the acquihire, and then all the other employees didn't get access to that. So how do we make sure that the
Better,
employees get access
better
to that,
lawyers, man. You
whatever those
know,
investors are getting?
Yeah, and you wonder like, will this problem with the employees who are getting bad treatment right now, will it work itself out relatively quickly? I mean, it probably would work out better if we weren't in this problem of a hiring glut. Like the
They just don't have the
workers
market
don't have a
power.
lot of
Yeah.
sway right now, but you figure that will probably work itself out sooner or later. Like acquihires can't screw all the employees forever. But
Yeah,
yeah,
I
I
mean,
mean,
I think,
go
sorry,
ahead.
Dave.
That's okay. Go ahead, please.
Yeah, I really worry about just the general chilling effect if fewer people start companies because
Mhm.
they are unable to hire or they feel that they're not going to have outcomes, or you have one or two people who join the thing and then you can't really get it further than that because of this friction and concern about, well, what if we get windsurfed, as it were. Hopefully that becomes a verb. But the and we lose a lot of innovation from that. And on the other side of the coin, it's never been cheaper to build things that matter.
Yeah.
Um, when I really started working in Silicon Valley was the sort of 2010 period of cloud computing, and you know cloud enabled folks to deploy stuff anywhere. And previously, you had to have your own servers, and there was just a huge upfront cost if
Mhm.
you want to get something onto the web at any sort of meaningful scale. And between the AI tool chain being able to develop software for you, AI graphic generation tools where you can make passable designs for websites very quickly, non-technical folks and especially technical folks are now able to be sort of a team of one or a team of two and build something really great and get it to market. And so like I don't know how this is going to sort of change and shake out,
Yeah.
where will there just be a lot more tiny companies because that's where what economically makes sense and where you have the highest upside,
Mhm.
um, or yeah, I don't know.
I don't know. And it's very interesting. Chris and I talk about these kind of issues a lot. I feel like, and this feels like a very common story in technology. Like innovations scare people
Mhm.
all the time. They have been for hundreds of years, and then things tend to more or less work out. Like some people lose in the short term, that is for sure. And I kind of wish we had a better way of addressing it. But it is definitely part of the innovation story that, settled expectations won't be settled forever, and things will be okay once they're resettled.
I wonder if regulators could actually improve what's going on here by doing something counterintuitive, which
Mm.
is right now the push towards these acquihires is definitely creating problems for incentives to work at startups, incentives to invest in startups, incentives to start startups. And so if we're essentially undermining innovation when we are encouraging companies to go this acquihire route instead of the acquisition route. And
Mhm.
then we also potentially want in these types of technologies like AI, where first mover advantage and speed to market are critical because of the lack of patent protection, we probably want acquisitions to go fast.
Mhm.
And so if we want to actually promote innovation in this space, and so perhaps if regulators were to signal, please move fast, we're generally not going to go after these unless this, and this condition are going to be met, then maybe that would actually help everybody in the marketplace and incentivize continuing innovation. I don't think they would
Hmm.
actually do that, but it would be interesting if they could just signal,
Yeah,
hey, we're not
that's
going to go after you for
super
this.
interesting. I mean, the antitrust regulators won't do that, for better or
Hmm.
worse. There's a lot of regulators with their thumbs in this pie. The Securities and Exchange Commission takes different views in different administrations, and they might,
Yeah.
there are times when they're like, yeah, do your streamlined acquisitions or whatever, streamlined deals for efficiency, blah blah blah. And Congress often supports that. So maybe they will. I don't know. I'm not sure. I mean, again, reasonable minds can differ how much innovation is enough or how much encouragement for it is enough. I mean, I think humbly, I believe that innovation in AI is at least sufficiently motivated right now, right? Like I heard recently that, some hugely significant fraction of US GDP right now
Right.
is spending, capital infrastructure spending to support
All the
AI compute.
investors. I think, Chris Toswell, you mentioned that the Y Combinator investments are have a huge portion of AI companies right now.
Absolutely.
Yeah.
No, the stats are
So
staggering.
maybe there is sufficient AI investment.
Yeah, I mean, it's always, I feel like the conversation is always about how can we more, actively encourage innovation. And I feel like innovation is doing fine. At least it has been in my adult lifetime. And I don't know, maybe I'm wrong, but we often sacrifice, it feels to me like lots and lots of other values to it. And I don't know. It's easy to say, hey, antitrust is going to screw up this 21st century space with an 1890 law. And maybe that's the right criticism, but I think by not having a competition policy, which we haven't had for a long time, and probably other meaningful policies that we sort of just can't enforce very well, we've caused ourselves a lot of problems.
Hmm.
And I don't have a good solution to it, but I wish we could do this better.
Chris
Not
Toswell, you
to
got another thought? Yeah.
expanding out also, because we haven't talked about it at all, and I don't know to the degree in which you've studied this side of it too. You have outside of the US, you obviously have the
Yeah,
EU, which has taken a stance against many acquisitions, and
yeah, for
I don't know if
sure.
you could add any clarity around
Oh, sure.
um, how
Um,
how the EU, because even if our regulators said yes, cool, we're going to say
yeah, sure.
we'll get anything done in 3 months or less, gold
Yeah.
star.
The
Uh, EU
in
could do
these
something
particular
differently.
spaces, in high tech spaces, we really are not just talking about the United States. We hear a lot about the United States and the EU, but I believe there's something like 125 national competition systems now, most of which have pre-merger filing requirements. So every big deal for companies that compete globally, which is every company in big tech, pretty much. There's more than 100 pre-merger processes to go through, and they all have their own timelines. They all have their own national substantive law that the companies are supposed to comply with, and it's very complicated, very cumbersome. Still, the United States, Europe, the European Union, some European states, and Australia and a few other countries are by far the most important. They're almost the only ones that ever pose serious problems to these deals, but it's all very complicated. I mean, the substantive law for having said all that is still largely the same. Few of those legal systems actually ever stop or significantly constrain a merger, despite what you might hear from almost anyone in Silicon Valley. The European Union, I don't think, is actually declared war on Silicon Valley and isn't regulating it as an attack on American institutions or national protectionism. I mean, I think they believe in their competition policy just slightly more than the United States does, and I mean, really, just slightly. Like I know they've socked Google a lot of times, but they haven't gone quite as crazy, I think, as the common theme would suggest. The role it plays in reverse acquihires or acquihires is very interesting to me and very complicated. Like, does this get you out of review in the European Union? I don't know.
Mhm. I think
Complicated.
there was one of them that did get reviewed. Was it the Microsoft Inflection AI deal? Got reviewed by a UK
Yeah,
regulator.
UK
They said
just
it was
approved it.
fine.
So
Yeah.
it's not exactly case closed, right? It's not necessarily proving my point, but I think most of these deals are going to do fine in Europe, just as they are going to do here.
Hmm. Interesting. So, well, I think this wraps up a lot of what I the thoughts that I had on it. Do you guys have anything else that you want to add before we close out?
Yeah,
It's
I
just
think
it's always so fun. I
Yeah.
love talking to you guys about this stuff.
Oh, well, thank you for joining and having this discussion. I think it's really fun to get this combination of expertise together. I really appreciate it. And thanks again.
So, thank you.
Thank you.